Is there going to be a mental health defense in the Richard Allen case? We are getting close to having a jury in the Chad Daybell trial, probably by Monday. More fighting in the Kohberher matter, a story of a bad man, and a story about a mama who don't play. Those are her words. And yes, our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure you hit that little bell so that you receive notifications of when we go live or put up new content. And I say that repeatedly because, well, if I don't ask, you don't do it. And then I have people say, how come I'm not getting notifications that you're putting up new videos? So hit that little bell. Make sure you have hit the little bell, ladies and gentlemen. We appreciate it. And remember, you can listen to us anytime on any of your podcasting apps. All right, let's go ahead and get ready to do the docket. Yes, we are uploading the video of the last couple of days of George Kelly's trial. As you may recall, Mr. Kelly is on trial for the killing of a man who was on his property, and he said that he was in fear of being injured. Anyway, the government didn't believe him, and he's on trial. He's 75 years old. Originally, the trial was being streamed, but then the court said that due to bandwidth issues, they were no longer able to do that. We have been downloading to upload those videos to you, so if you'd like to check that out, you certainly can do that. It's a very interesting trial, and it's going to be an issue as to whether it was imminent fear. That's for sure. Now, and next week we'll have the hearing for Bryan Kohberher as well. Seems like the niceties and professionalism are wearing off and the gloves are coming off. So who knows what's going to happen next week, but we'll talk about that in just a minute as well. All right, first on the docket, Richard Allen, is there going to be a mental health defense? So as you may recall, and I had to go back and look, the prosecution has been trying to get the mental health records for Richard Allen while he has been in custody. There's been some alluding to that there may be some sort of mental health defense. Well, it's very unlikely that there be any sort of mental health defense going back to when the alleged murders took place back in 2017. So what is the issue? Well, prosecutors have filed 3 motions, and the last one was withdrawn where they tried to get the mental health records. But now the prosecutors have been given access to Richard Allen's mental health records while he was in custody. Now, the judge granted the request without a hearing this week, and the prosecutors subpoenas Allen's mental and medical records for the period of time since his arrest. And their position was that, well, the attorneys could use a mental health defense in his trial, which begins in May. Well, what indication do we have that that's actually going to take place? Well, yesterday, and April 4th, the defense gave notice that they were turning over an independent neuropsychological evaluation by a Dr. Polly Westcott, and that report is dated March 31st, 2024. So, what does that mean? Well, we don't like to speculate, but I think we can make a pretty educated guess. There's been some information that's come out that the prosecution has alleged that Mr. Allen has confessed to these murders that he's charged with while he's been in custody. And, well, what's the best way to explain statements that may have been made to mental health professionals? Well, is to show that he was under extreme emotional and psychological distress, and that he may have said some things that he didn't mean. Maybe like, oh, sure, I did it if that's what'll get me to more comfortable conditions here. So obviously we're going to have to wait and see. And unfortunately, the judge has said she's not going to televise the trial for Mr. Allen, which I think is a huge shame. This is exactly why everybody should be able to see what takes place in that trial. And if it all works out, well, maybe we'll swing by while we're jetting around in Crime Talk 1 this summer. We'll see. Next on the docket, Chad Daybell. We almost have a jury, ladies and gentlemen. I don't know if you've been watching. I have been trying to watch the jury selection process for Chad Daybell. And for those who aren't familiar with it, jury selection began there in Ada County, which is in Boise, Idaho. And the trial is scheduled to last from 8 to 10 weeks. And Chad Daybell is charged with the first-degree murder, conspiracy to commit first-degrry murder, and grand theft over the deaths of his first wife, Tammy, and Lori Vallow's children, Tylee Ryan and J.J. Vallow, who was only 7 at the time of his death. Now, the jury selection had finished up on its 5th day. They ended, about 11 o'clock, 12 o'clock Idaho time out there. And I think they ended up about 12 o'clock Pacific time today out there in Boise, Idaho. They have enough jurors so that they can do their general voir dire to those jurors and begin the peremptory challenges. Now, this is a death penalty case, and it's critical for the court to have enough jurors that can appropriately try the case and stay impartial. That's a little difficult, obviously, because this has been a high-profile case, and there's been a lot of media coverage over the last 4 years. Now, the court needs at least 50 jurors because when everybody exercises their peremptory challenges, which are challenges where the prosecution can get rid of anyone and the defense can get rid of any potential juror for any reason. And when you do that, to get to the 12 jurors plus the 6 alternates, you need at least 50. However, despite getting to the magic number of 52 yesterday, the court is trying to give itself a little bit of a buffer. Why? Well, a lot of those jurors who've been qualified maybe didn't engage in individual voir dire, and there was nothing that jumped out at anybody for the information that they put on their juror questionnaires. So when they bring everybody back in, you're going to have people that are going to say, well, I filled out the questionnaire. No one really has asked me anything, but I didn't really think I would get this far. So I've got some hardships. Did I tell you about the vacation that I planned? Yes, those types of things will come up. Or somebody will say, oh, yeah, I need to get out of jury. This is really not good. Did I tell you my wife just happened to play the Netflix series on the case of Chad Daybell and Lori Vallow? I think I've made up my mind. People will do this, ladies and gentlemen. And so the court wants to have enough because if some of those jurors that are in that 50, the presumptive 50 jurors there, drops out, you got to have a couple to fill those in. If you don't have enough jurors to fill in those people that may get dismissed, guess what? You got to start all over again. That would be problematic. So it's best to have a few extra bodies just in case. Now, like I said, the court needs to get to the 18 jurors, 12 plus 6 alternates, and the alternates will sit in for the entirety of the trial, but only find out that they are the alternates when the actual jury deliberations begin because they're told to collect their things. They're not going back to the jury room. So we'll see. And over the course of an 8 to 10 week trial, the chances of losing a couple of jurors for the unknown, the unexpected, is bound to take place. So tune in Monday morning, 9 a.m. We will have the jury selection process, and hopefully we can roll straight into opening arguments. Now, the interesting thing about voir dire is everybody kind of pitches their theory of the case. The prosecution's talking about, hey, we don't have to prove who killed everybody. We just have to show that there was a conspiracy to kill everybody. And as long as you think somebody killed these people, close enough for us. Now, yesterday, Chad Daybell was kind of pitching his theory as well. He brought up a country song that he liked where shiny things aren't always gold, kind of referring to, that's right, Lori Vallow, that somehow this shiny little object, Lori Vallow, that he thought was, the greatest thing ever. I mean, Chad Daybell thought that, and that kind of rocked his world, Well, it turned out to be nothing but trouble, not exactly what he thought he was getting into. Obviously, that's the defense I've been saying is going to take place for the next 4 years. Chad Daybell is going to say, you know what? Here I am, middle-aged guy, this beautiful girl, woman, rocks my world. She wants to be with me. Next thing you know, everybody starts dying around me. I have no idea, but I'm just kind of going along with the moment. He's going to have some explaining to do for sure, but that's the theory of the defense that I see developing. Obviously, we'll have to wait and see what we find out, at least in opening statements, which is just a preview, not a guarantee, but you don't want to tell jurors something that you're not going to be able to promise them that comes into evidence. So we'll have to wait and see. All right, next, the Bryan Kohberher matter. Things keep getting hotter in the Kohberher matter. Now, there was a hearing as it related yesterday to the survey that the defense was conducting. Some people are like, oh, who's being petty now, Scott? Wasn't the prosecutor. The judge was upset. Well, if you watch the entire video and you watch the live at the end, I talked about everybody overreacted. The judge overreacted. The prosecutor overreacted. The defense maybe got a little bit over their skis. I don't think so, because they did nothing wrong, in my humble opinion. Now, the court's saying, well, you're telling people information that's not true. And the defense was saying, but judge, that's what's in the media. That's the problem with it. That's why we're trying to show if these people know about this information and they believe it to be true and it's not, guess what? They're tainted. That's why I would bet somebody, not everybody, because I couldn't, well, actually, I would bet them the largest steak dinner in Colorado that this case will not go in Latah County, but it'll be moved to Ada County. I would make that bet. Someone's going to be buying me a lot of big steak dinners because I think I'm going to win that bet. It's not going to remain there, regardless of how strong the prosecutor is going to say that it should remain there, or even the judge who believes he's unwilling. I believe that when they, even if he didn't grant a change of venue prior to the jury selection process, by the time they get to the jury selection process, he would have to do it. So just do it, move it, be safe, give the man a fair trial, let the prosecution present their evidence, let the chips fall where they may. I don't have any particular feeling one way or the other on this case, but we want fair trials for both sides. And some people said, oh, Scott, all you do is criticize the prosecution. No. In fact, I've been very favorable to the prosecution, only calling them out on a couple of occasions. And I think I've been very critical of the defense in the Kohberher matter as well. Now, here's another thing that, well, as you remember, Bryan Kohberher was arrested because of this genealogical data that was developed by the FBI, which was later used to develop a lead, which then they got the court order for the DNA sample for Bryan Kohberher, which matched the alleged DNA that was found at the scene. The defense requested all the genealogical information that the FBI used. The prosecution fought it, said, no, we're not going to use it, not relevant, not in our control, not going to use it. The judge said, no, you have to turn over specific items that the FBI relied upon. That's just the way it is. That's freaking prosecution 101 type stuff. And they agreed. The defense then filed just recently a motion for more of the genealogical information, the IgG information, and basically has attached a document they just refer to as Exhibit N in their motion, saying this is why we need more information. The prosecution has yet again objected to that, and the court will ultimately decide. This is what I have a problem with when it comes to prosecutors. Any prosecutor, give them what they want. Give the defense whatever they want, and still go out and convict them. If it's so irrelevant and it doesn't matter, let the defense go chase all that stuff down and let them try and focus on that. Is relevant, then it should have been turned over in the first place. So another dispute brewing between the prosecutors and the defense as it relates to these documents as well. It's going to start heating up. Now, I know the judge in the Kohberher matter, Judge, doesn't listen to me. But like any criminal case or civil case, a job expands to the amount of time given. It's a very simple principle, applies to just about every type of situation. The judge needs to set hard dates on his schedule and make the other attorneys comply with that schedule instead of just dragging this stuff out. I get it. It's a death penalty case. But remember, the defense originally said they were ready to go early on in the case, and everybody knew they weren't. It was a bluff. And then they waived speedy trial, and here we are. It's going to take 4 years to get the trial. So, judge, set some dates, whether it's convenient for everybody else or not. Just set it and make everybody else work around those schedules. Clearly, the prosecution wasn't ready early on. The defense wasn't ready early on. And frankly, that would have been the only shot, I think, for Mr. Kohberher to really have a shot to win this case. Now, I don't know. We don't know all the evidence, but I think I do understand juries, and juries generally are quite persuaded by DNA evidence. And if that DNA evidence is on the knife sheath, turns out to be Mr. Kohberher's, he's got some explaining to do. All right, next on the docket, a bad man. Okay, this dude, William McClish, well, a jury convicted him yesterday of attempted first-degree murder against a law enforcement officer, resisting an officer, and violence and aggravated battery on a law enforcement officer with great bodily harm, depriving an officer of means of protection. That's a fancy way of saying that he took his gun and communications and attempted to deprive the officers of protection and communication. The judge sentenced Mr. McClish to life in prison. Now, I'm going to go on a limb here, but yes, Mr. McClish got exactly what he deserves, and he is where he belongs. So how was it that Mr. McClish got to this situation that resulted in life in prison? Well, back in September of 2021, Mr. McClish placed a phone against a trash can in the area where he was parked. Now, there were 2 Orlando Police Department officers in uniform that were standing outside of their vehicle. So while the officers were in view of the camera, McClish began streaming live on Facebook and then hit the officers in the head with a brick. Now, according to the district attorney's officers, the officer and the witness tried to subdue Mr. McClish as he continued to fight and resist. Mr. McClish also reportedly bit and gouged the second officer's eyes during the attack. McClish refused to comply with the officer's commands, and Mr. McClish tried to retrieve one of the officer's guns. McClish took an officer's radio off his uniform to prevent him from calling for help, and additional law enforcement officers arrived as well to apprehend Mr. McClish at the scene. Now, according to the district attorney's office, while he was in jail, Mr. McClish bragged about trying to take the officer's firearm during the attack. Now, in the video footage that was obtained from Mr. McClish's phone, investigators learned that Mr. McClish said, quote, "I'm going to kill him on live." So the prosecutors thought that's premeditation of intent to kill somebody. The jury agreed, probably being found guilty. Now, Mr. McClish, being the intelligent man that he is, what did he do? That's right. He represented himself at trial. And his opening statement said, "I didn't do it, and the evidence was tampered with." Good defense. Good defense, Mr. McClish. Not really sure that worked out too well for you. But anyway, it seems like you're a bad dude, and I'm okay with you spending the rest of your life in prison. Next, a mama that don't play. One of the most refreshing things that I've read in a long time. So, 2 suspects were wanted for shooting at a police officer, and guess what? Their mom turned them in just the other day. Now, how did this all come about? Well, it started from an alleged traffic stop in Holly Springs, Tennessee on Tuesday morning. Then a sheriff deputy spotted the car where the suspects ran into the woods. Now, the suspects were caught on a Ring doorbell camera shortly after the shooting, and their images were released to the public by the police. Good police work, right? Well, guess what? About 24 hours later, the suspect's mother turned both of her boys into the police. She said, quote, "I don't play no games with them." If you want to do the crime, you got to do the time. Plain and simple. That's according to the mom. After she turned in her 17 and 18-year-old son into the police, and she said, "My child does not get in trouble. He don't bother nobody," she said. "They don't do nothing. All they do is play games. This is very new. This is shocking," according to the mom. But the mother said that her son told her they are innocent, and she is hopeful that turning them in will result in having their good names cleared. Both sons have been charged with aggravated assault on a peace officer, and there is an additional person of interest in the case, and he has not been apprehended or charged just yet. Kind of refreshing, isn't it, ladies and gentlemen? I mean, I don't know about you, but when I grew up, that was the kind of thing, if my parents thought I was in trouble, they would have, heck, I know my dad once marched my brother up to the police station and turned him in for, I think they found marijuana in his room. Took it up to the police station and said, charge him. Obviously, times have changed, but remember, parents, it's not your job to be your kid's best friend. It's your job to be their parent. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. And next, our dumb criminal of the day. An Iowa man has been accused of exposing himself to an 11-year-old girl while he trailed her through a Walmart toy aisle. Fortunately, there was some surveillance camera of the guy. Now, the alleged lewd act, investigators say, occurred about 4 months ago at a Walmart supercenter in Iowa City. The child told the police that an adult followed her into the store, and when she looked over at the man, well, guess what? He was exposing himself and pleasuring himself. I'm sure every 11-year-old's dream. I don't think so. Anyway, the Walmart security video showed the man following the young girl out of the toy aisle just before the victim reported the incident to her mother and store employees. Now, in seeking the public's help to identify the pervert, well, the police posted an image from the Walmart on their police Facebook page. And after the image appeared on the Iowa City Police Department's Facebook page, guess what? Did somebody identify the guy? No, even better. Dustin Hills called in to request his photo to be removed from the Facebook page. Now, of course, police didn't do that at his request, but Mr. Hill was arrested and charged with indecent exposure and aggravated misdemeanor, for which he is now locked up in lieu of a $5,000 bond. Now, according to the court records, Mr. Hill's rap sheet includes a 2014 conviction of indecent exposure, as well as convictions for thefts, narcotic possession, probation violation, and drug paraphernalia. In the earlier incident where he was charged and convicted of indecent exposure, a woman spotted Mr. Hills displaying his genitalia and pleasuring himself while standing in a nearby apartment window. Mr. Hills admitted to accidentally displaying his erect genitalia to others outside. He claimed to be an adult. Website at the time of the second incident. Mr. Hills resides in West Branch, which is a city in Iowa, and coincidentally just about 15 miles from the Walmart where he resides. Mr. Hills, you are a dumb criminal of the day. Is it because you're a pervert? No, there's lots of perverts out there, Mr. Hills. Heck, we talk about them all the time. You're an idiot and you're a pervert for doing what you did to that 11-year-old girl, but to call up to the police and say, please take down my picture? Really? Did you think you weren't going to get arrested? You are our dumb criminal of the day. All right, ladies and gentlemen, thanks for watching. Have a wonderful weekend, and we'll see you Monday on Crime Talk.